Section 73 of your Indian Contract Act is the touchstone of remedies. So to those people who always ask that what are the provisions of law, I have told you that any provision of law that you need to understand, at least not learn by heart. I don't believe in this learn by heart concept, but at least conceptually understand. I will always point it out. Okay? Section 73 Indian Contract Act. This is a touchstone when it comes to remedies, concept of damages. Very important section. Please don't miss this section. Revise this section. Even if you know the concept, revise this all over again. Okay? It's a very important section for you to know. Now, when it comes to remedies, the most or the damages, okay? From drafting perspective, the most important concept that you need to know and understand is the concept of liquidated and unliquidated damages. Okay? Why this concept of liquidated damages is important when it comes to drafting? Okay. Just imagine this entire scenario where you and I have entered into an agreement. Okay? Tomorrow you have done something wrong, you have breached some provision, some clause, something, some activity, and we have this total dispute here. Okay? Regarding damages, now I am going to claim damages from you. Okay? Imagine two situations can occur here. Okay? One, my agreement specifies the exact amount of damage that you need to pay. Okay? It is not going to save us a lot of time today. Suppose your agreement specifies in case of such kind of a breach, 100 rupees damages is going to be paid by this other person. Simple, 100 rupees you pay me, we are done there. No altercation, no need of going for ADRs or court, civil suit, nothing. Imagine the opposite situation where there is no specification, no capturing of the amount of damages. Now, I am telling you I need 200 rupees, you are saying, nahi bhai, mere ko nahi dena hai 200, I will give you 100. Resultant, what will happen is either we will go for certain kind of arbitration, alternate dispute resolution, or file for a civil suit. Okay? Always remember that if I draft an agreement very well today, my agreement is going to be the Bible for the disputes that occur tomorrow for my client. My agreement is going to absolutely answer all kind of disputes that occur, and it should ideally answer all kinds of disputes that occur. That is my job as a lawyer. I should contemplate what kind of disputes that can land up tomorrow and just have an answer in my agreement for those disputes. That's the job of a person who can draft well. Always remember. Okay? So, liquidated damages. Now, unliquidated damages also becomes very important because there are certain things which you actually cannot quantify. Okay? Loss of goodwill, loss of reputation, all of these also are actual loss when we talk about in commercial terms. Okay, for a business, loss of face, loss of goodwill, reputation, it can cost a lot. So I am not saying that tomorrow you can have liquidated damages for everything, or you are going to absolutely restrict everything to liquidated damages, but as much as you can quantify, you try to quantify. And the things that you cannot quantify, okay, at least try to have a resolution mechanism in the agreement itself, okay? Like basically tomorrow, the less amount of civil litigations your client is going to have, the more your client is going to basically benefit from the agreement. That's what I want to tell. Okay? So, material breach and basically liquidated damages. Just read section 73. There are a lot of kinds of damages, but honestly speaking, nominal damage, pecuniary damage, we don't basically exemplary damage. These are not something we will actually consider putting in our drafts. Okay, these are conceptually for college level understanding and all theoretical understanding. Okay, but exemplary damages is something that the code gives. Okay, nominal damages is something the code gives. Nothing that can actually help me as a drafter or as a lawyer when it comes to drafting. Conceptually, I have given you everything out here, the kinds of damages that are there, whatever it is. Okay? Ordinary damage, special damage. I have given you a little bit of examples, simple examples in this document. Okay, exemplary damage kya hota hai, consequential damages kya hota hai. All of this I have given you here. Okay? Just very short 2-3 page material. In case you are interested to understand this, just read this much. Conceptually, you will be clear. Okay? इससे ज़्यादा you actually don't need to know about it. from drafting perspective, you just need to know about the concept of material breach and capturing the material breach, and basically your liquidated and unliquidated damage. Okay? Theoretical perspective से this is enough. Any doubts so far before I move to your this thing, live drafting? Anybody has? Yes, Sonali. Every PPT material, everything I will share. No secret, nothing. Vishalakshi, all points I will say again. 2 points only. Okay. Material breach and this thing, your liquidated and unliquidated damages. Smithali, material breach you can actually include in your definition clause, but personally I always prefer to capture them in your termination clause. अच्छा, by the way, breach clause करके generally in actual agreements कुछ नहीं होता है, ठीक है? This is for the purpose of the exercise. This material breach thing or events of default, whatever it is, this is actually captured. You can see it in live templates also. This is actually captured in your termination clause as grounds for termination. Okay? So this breach thing, this is actually practically it's not a clause. Okay? So we actually don't use the term breach and all. Termination pe we basically make a pointer on the grounds on which the agreement can be terminated. We define the material breach there and basically capture it as grounds for termination. Okay? In material breach, money can be claimed. What will be the remedy for residuary breach? We need both for material and residuary breach basically. See, residuary breach now it depends. If it is an, as I told you, it does not have any overall too much implication on the agreement, you don't go for claiming damages or anything. If it has an implication, then it is not going to be a residuary breach. It is actually de facto going to be a material breach. Okay. So that is exactly the point that I'm trying to make, that in your agreement, you focus only on your material breach. Let go of the residuary breach, because tomorrow if I actually try to capture everything as the breach and start claiming damages, practically just think it is execution is going to be a huge issue actually. Okay, so what happens actually in live cases, I'll tell you, if there's a material breach, okay, there are 2 things. One, a cure period is given. Okay? So cure period matlab say suppose 15 days time I have given you. I'll give you a notice that this breach you have made. Now you have like this 15 days time. Either you cure this or I will now terminate the contract and sue you for damages. 15 days means you cure it, well and good. You fail to cure it, what the person does is, additionally with termination clause, your indemnity clause is invoked. Indemnity clause is basically the clause where you can claim your damages, right? Okay? So you just basically straight away invoke the indemnity clause. This is how in practical scenario this functions. Okay? Can you please go through unliquidated damages? Bharti, liquidated damages is if I just specify the quantum of damages. Okay? Sometimes it is specified as twice the amount of contract, half the amount of contract. So 100 rupees ka contract hai, 50 rupees I'll give straight away as damage. 100 rupees ka basically the contract amount is 200 rupees, twice the amount of contract I'll pay as damages. This you just capture in your agreement. In your indemnity clause only, you just straight away quantum kitna damage denge, you capture it. Unliquidated damages are the damages where you cannot basically, either you don't capture the quantum or you cannot capture the quantum. Okay? So you don't specify the amount, you make a general statement that damages can be claimed in basically such events of default. Okay, Bharti? Got it? Can you suggest any template for reference purpose? Sonali, we will give you templates, don't worry. We will give you templates. I will share extra templates also with you. From the stage from where you need actual templates, I will share with you. Don't worry. Okay? Ma'am, while drafting, can you please read out where we have to write in caps and we have to put... of course, Muskan. Of course. I'll read out. No worries. Ma'am, so material breach will be drafted in termination clause. Exactly, Priya. Yes. I will show it to you also. Don't worry. For this exercise, you take it as breach only. When we go for commercial contracts, I will show you where and how it is defined. Okay? Bharti, since basically after the session, I will share the material that I am using here also on your Discord also. Both places I will share. Okay? How do we specify damage claim in loss of goodwill? Okay, Mitali, thing is, see, goodwill, you can actually quantify loss of goodwill. There are actually methods. I don't know if anybody is a CA or a CS here. I am not a CA or a CS, but there is actually a valuation of goodwill method. Okay, there's some method called weighted average method, something. I'm not very sure, but I know weighted average is actually one of the methods to calculate goodwill. So basically, your chartered accountants generally do this kind of valuation. Okay, not our job. We are lawyers. Okay, so it is done, but generally, when it comes to agreements, we don't actually practically try to quantify this goodwill or reputation loss and all that. We keep it as unliquidated damages. Okay. But if we want to also, sometimes people prefer liquidating every sort of damages. Like I can show you agreements which has like literally every single, like there are 10 to 15 pointers like on which the beautifully drafted agreements. Okay, I can show it to you that with 10 to 15 points where they have actually captured every single thing. Like you can't contemplate anything outside that. Literally you can't contemplate outside anything that. They have captured, they had quantified every single kind of damages. Beautifully drafted agreements. Okay, you can do that, but the valuation part is not our work. That the company will have certain person to evaluate it and everything. So that you can just put the amount. Is there any kind of limit or what will be the quantum? No, Vishnu. Limit ऐसा कुछ नहीं होता है. It is depending totally on the negotiation between the parties. See, liquidated damages basically first of all have to be something that the parties have agreed upon, okay, before executing the contract. So obviously, since you're capturing it in the agreement, it is something that the parties have properly agreed, legit agreed upon, okay, and after they have negotiated, they will put that amount. So there's no such limit, whatever the parties will have basically. I mean, obviously, like if the contract amount is of 100 rupees and I am claiming like any illogical value won't do. I mean, nobody will agree to that also, right? So it has to be a logical deduction at the end of the day, but there's no such limit. Vineet, I'll show it to you later. When we move to commercial agreements, I'll show you different kinds of templates. Don't worry. I have it in store. Don't worry. I'll show it to you. All kinds of agreements. I'll show it to you. Okay, fine. Anybody has any other question, or can I move to the drafting part? Anybody else wants to ask anything? Is it all clear to all of you? Okay, all right, fine. First, let me copy paste the exercise facts. Then we will. Okay. Now, when we see this week's exercise, है ना? ठीक है? Besides this blah 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 facts and definitions and all, है ना? What we have here is that certain points that the parties have basically agreed upon themselves. These are your negotiation points, you can say. Okay? Now you will see that what are the clauses we have asked you to draft here. One is the payment obligation clause, right? Okay? Second is the breach clause, right? You can see here that all these points can actually be divided into either some points will belong to your payment obligation and certain points will belong to your breach clause. Okay? So I have copy pasted it here. 1 second. I'm going to tell you a method which I have already told you, I think, but I don't know if you have started following it. If not, this is actually the ideal exercise from which you can start following this. What is that? Preparing a checklist before starting the draft. Okay? So now, see, I have highlighted I'll draft the payment obligation. Okay? Now, payment obligation, I have already highlighted the points that basically belongs to your payment obligation. First point is when an order will be placed by distributor, 50% will be paid as advance amount. Okay, 1 point. Payment will be strictly made in cash. ये practically नहीं होता है. It means black money transaction हो रही है. ठीक है? But this is a hypothetical scenario. I can use whatever I want. After the dispatch is made and communicated to the distributor, balance amount. Now 50% advance amount. ठीक है? Rest 50% after 7 days, or sorry, within 7 days of the dispatch will be paid. And balance payment can be now for the advance payment, cash has to be used. For balance payment, you have to use cash or check, either whichever you want. So these are the 4 points I have to capture. ठीक है? Well, now forget these 4 points for some time. ठीक है? Forget these 4 points. Let's just try to understand in general what the payment clause should contain. In general, any XYZ payment clause, consideration clause tomorrow you draft. ठीक है? Obviously, the consideration amount, how much consideration needs to be paid. Correct? Who needs to pay, on whom the burden of payment is there, right? And by when. Always remember there is a payment schedule to be attached. What is the payment schedule? Generally, it's suppose there are 2 ways of payment. Here you can see, right, there are 2 tranches or 2 basically halves in which the payment is made, right? So either payment can be made in one time. Rent, within 5th I will pay 10,000 rent, 10,000 within 5th I will pay. Or 5,000 I'm going to break up. Practically नहीं होता है, just समझा रही हूँ, ठीक है? 5,000 I will pay by say 1st of the month. Rest 5,000 I will pay 15th of the month. There are 2 tranches. Commercial agreements is worth what? Almost 50 lakhs, 1 crore, 2 crore. So basically there is always the schedule or tranches of payment, ठीक है? By first schedule, basically this much amount will be credited by this much time. So this is called the payment schedule. Generally, for very big like very big tranches or very big commercial agreements, this payment schedule can additionally be attached in your annexure or schedule also. Instead of basically keeping it in your as a part of your main contract, you can actually annex this as a part of the as an annexure or in the schedule also. Okay, this is also there, but you don't need to. Yeah, so you don't need to worry about that part. Okay, so fine. So these are the 3 things first. Okay, now